Now, I was shocked to discover this. I mean, did you know that sub-Saharan Africa has the worst health on average in the world? So although the region has 11% of the whole world's population, it carries a disappointing 25% of global disease burden. So please join the Multimedia Group and the Commonwealth to discuss how we can change this narrative at the Commonwealth Speakers Series. What are the problems? What are the challenges, the solutions to Africa's healthcare provision and system problems? The venue is the Business Council, the British Council, forgive me, in Accra. And the date is the 26th of November 2019 from 5 p.m. Our health partner is Luca Health Medical Specialty Center. Media partner is the Multimedia Group. And of course, supporters are Premier Health Insurance and Yox Rent-A-Car. So listen, send your health questions for the Speaker Series to us at Joy 99.7 FM or at the RCS Africa. Do that and please be a part of this all-important event. Now, there have been a number of calls on government to decriminalize petty or minor offences and allow for fines and communal labour as punishment for them. Now, petty offences have existed as part of the criminal law of England, and we, of course, have incorporated them into our laws in Ghana following colonization. Now, modern trends in governance, human rights and the rule of law have triggered reforms in the criminal law of a number of countries, including England. Law reforms towards decriminalization of petty offences have happened all over the globe. It's also been influenced by disproportionate impact of the enforcement of such laws on the poor, the disadvantaged and the marginalized sections of society. To top all that, our prisons are also congested. As a result, increasing the poor state of health in our correctional facilities and making it more difficult for those who are put there to be reformed. Meanwhile, there are a lot of sanitation and other challenges that people who commit minor offences could be made to address. Joining us today on The Pulse is the Greater Accra Regional Director of SHRAJ, Maria Jile Nate, and Project Officer of the Commonwealth Human Rights Initiative, who have also been championing the agenda. It's very nice to meet you both. Thank you so much. So why don't we dig straight into this? And perhaps I'll start with you, Mary. Why has it taken it this long for institutions like yours, groups like yours, to point out the obvious, that we are overcrowding our prisons with people who could serve themselves and society better through non-custodial sentences?
Thank you very much. The call for such has been going on for years. I remember the commission over the years go on prison inspection, we write reports, we make recommendations to decongest the prisons for the mere fact that a lot of human rights violations are going on there. And so the call has been ongoing, except that now we are calling for policy change. We are calling for legal reforms, and we are calling for repeals and what have you.
All right. So what's the first point of call here? Is it Parliament? You just want Parliament to do something about this? Or is it squarely in the hands of the judiciary?
No, the first point of call, of course, is the state. And when we talk of the state, we are looking at institutions such as the Ages Department, who will be called upon to draft and review the law. We are looking at Parliament, which represents the people on the ground, and the fact that they make laws, and this is their responsibility to review the law. And also we are calling on citizenry to also partner us to make the call a wider one, because it will take everyone to come to the point and realization that these petty offenses, which we may come in shortly to tell who they are and what they are and what they do to us as a society. We're calling on Parliament, we are calling on government, we're calling on institutions responsible for law reforms and what have you to help us change the status quo.
All right, so you're right. We will be talking about the specific offences that we want addressed. But first, let me touch on the event coming up, the talk. Why did we decide to use this opportunity to cast a light on this matter of all the issues we could discuss?
Right, just as Mary said, there has been an ongoing campaign already to decriminalize petty offences in Ghana. And the campaign has been ongoing with the help of media, with civil society. However, we've realized that there's the need to amplify, there's a need to, you know, make a lot more people aware of the campaign to decriminalize petty or minor offenses in Ghana. And that is why we've decided to have this event on November 27th to, you know, shed more light and make more people aware of this. Just because it's not just a Ghana event, actually, Kojo. It's an Africa-wide campaign. As far back as 2003, we were asking why have it taken so long. As far back as 2003, there was a Pan-African conference on penal and prison reform, which recommended that prisons in Africa are overcrowded, and so they ought to be, the prison population must be reduced. And so in 2017, the Africa Union adopted the principles that indeed all African countries should work towards reducing their, decriminalizing petty offenses to reduce prison populations. And so it's an Africa-wide campaign, not just Ghana. A number of countries in Africa actually have decriminalized petty offenses. And so Ghana hasn't, and that is why we are trying to raise the awareness. We are trying to tell the state that indeed there's a lot that ought to be done to decriminalize petty offenses, reduce prison population, and there are a number of alternatives to custodial sentencing, sending people to jail. There are alternatives when they commit minor offenses. So as Mary said, I think we'll discuss it.
Indeed. So what first,
let's add a little. The law is dynamic, and over the years, the law has developed. If you look at the human rights tenets and human rights treaties and principles, standards where the state has actually signed on to, most of these standards frown upon what we have in our law currently. And even looking at our Constitution, the Bill of Rights under Chapter 5 of the 1992 Constitution, there are lots of human rights provisions there which are not in tandem with the Criminal Law Act 29 as it is now. And therefore, the state is actually not obliging under our responsibility under international human rights law. And therefore, it's very important that we do such an exercise.
Right. Okay, so let's get specific. What are some of these offenses that you're thinking ought not attract custodial sentences? Okay,
what we are saying is that the criminal law is important. Nobody is ruling out the fact because it ensures social control, order in society. However, the law has been, let's say, divided into two parts, serious offenses and then minor offenses, what we call the misdemeanors. And we are saying that some of these misdemeanors, the punishment attached to it is what makes it minor. Because it's either you pay a fine or you go to prison less than 3 years, you understand, or the maximum being 3 years. These offenses normally cover public moral issues, public decency and all. You look at the issue of prostitution, brothel, operating a brothel, look at issue of habitual drunkenness, issue of loitering, issue of hawking, and a whole lot. These are all nuisance situations. They are all offenses which are minor and which could be done away with because, or even perpetrators could be given alternative sentencing than custodial sentences. Look at the prisons and look at what is going on. The right to dignity, the right to human dignity. Look at how they are sleeping. Look at the food they are eating, the environment and all. It violates the person's right to dignity, and we are saying that is improper. We should have a look at it.
So what, okay, sorry, you were going to add?
To what Mary said. We've realized, okay, at Commonwealth Human Rights Initiative, one of our key things is to visit police stations, to speak to people who are in detention and give them advice on rights and how for their rights to be enforced. And we realized a lot of people during the pre-trial detention, before they are even convicted, a lot of violations of their rights happening. Opposed to what Ghana has signed to, opposed to what our constitution says. Our constitution says if you are arrested in 48 hours, if you are not sent to court, you should be given bail. But there are people who go there and they are not given bail, they are not bail, they are there. And majority of offenders, of those who commit petty offenses, are the poor and the marginalized, and their rights get abused. There are some people, they get in there, they are there, and their dockets even get missing. Okay, some people are sent to in Sawam on remand, and that's it, they are forgotten about. Indeed, in Sawam was, when Sawam prisons was built, it was meant for 800 people. It will surprise you to know now there are over 2,000 people in Sawam prison, and majority of these people are petty offenders, you see. And the state does not gain much by having petty offenders in prison, because the state must take care of them morning, afternoon, evening. If they are sick, they are taken to hospital and stuff like that. So why don't you give them alternative sources of punishment, like fines, like let them do community service? If you ask all the district assemblies, one of the biggest expense items on their books is sanitation, clearing filth, desilting gutters, and we sent a lot of people to Nsawam for petty offenses. As you said, hawking, operating Okada business. Okada has not been legalized. So people who operate Okada business, when the city guards arrest them, they send them to court. They are fined. If somebody is fined, let's say 800 Ghana cedis, and the person has no money to pay, the person must serve a prison term, goes to Nsawam for 6 months. I mean, this we are saying it doesn't make sense. Traffic offenses are also an example. If a trotro driver, we are not saying that people who break the law should be set free. Not at all. We are saying that for offenses that are not serious, like murder, rape, for minor offenses, like, for example, Okada, a trotro driver who stops at a wrong place, and that person, there are alternative ways of punishing the person, not sending the person to jail, because the person, me and you, will not operate Okada business or, excuse me, do trotro, because at least we have some office job to do. Those people are trying to survive, you know. So we realize that over the years, the people who are the receiving end of petty sentencing offenses are the poor and the marginalized, and we need to respect their rights. We need to make sure that those people are also part of society, and we need to advocate for them.
So is it that currently a judge has no discretion to offer a non-custodial sentence?
Well, not at all. The Criminal Procedure Act at 30 actually provides for non-custodial sentencing, fines, compensation. But you realize from the research we have done or covered that mostly those options are not opted for. You understand?
Is there a reason? Have we been able to understand why?
Well, the criminal justice system in itself is a bit cumbersome. You understand? And so if for one reason or the other you go to court and you don't have a lawyer to defend you, someone to, you know, champion your cause, you probably may end up incarcerated. You understand?
That's interesting, though, because, I mean, the judges know what's happening in our prisons. They know it. Yes. They know that they are overcrowded. The police, the prosecution, they know. So what is the motivation to go and add more people to the overcrowded situation, especially when the offenses are, as you describe them, minor? What is the motivation? Why would they opt for custodial, even in spite of the knowledge of the problem it causes?
I think just to add to what Mary said, there is currently a bill in Parliament called the Non-Custodial Sentencing Bill, where the bill actually spells out, if you don't send somebody to prison, the alternatives that the judges can prefer for that person. However, this bill has not been passed into law yet. It's been in Parliament for years. So it's part of the advocacy we are doing, that this bill should be passed. If it's passed and codified into the law, then the judge knows that I can sentence such and such a person to maybe 5 months of cleaning gutters in circle, or 6 months of doing this. Okay, so they have that alternative. Currently, it's not been passed. So as they are saying,
so the judges can't exercise that discretion.
It's a matter of discretion.
So they can do it if they want to.
And I must tell you that some few years ago, the Justice for All reform system, where the former Chief Justice engaged into, you know, releasing, it was all in the path of ensuring that petty offenders are released from our prisons. So the judicial reform system is also ongoing, where justices are educated to also shun away from castrating people just because of petty offense, you understand? But the thing must be codified, the thing must be repealed, it must be taken out of the law, so the judge will not have the discretion at all as to whether or not I should put the person in prison, or whether I should let the person do some communal labor or do. We are saying that they have lost their sense of worth in our books, in our law books, based on development of the law, governance, rule of law, human rights. And so some of these things must be repealed, some of these
yeah, I mean, I wonder if I've made it, if it's clear to our audience the reason why I'm concerned that even though judges have the discretion, they appear not to use it. Because if anybody should be capable of using discretion, it's a judge. If a judge doesn't know how to use discretion, then who does?
I think this advocacy is something which is also empower the judges to, tilt more towards non-custodial sentencing than, custodial sentencing. So, the application of discretion is another thing in it all. You have power and you are exercising that power. However, reforms may challenge the way you apply that power. And that's why we are saying that the call for decriminalizing petty offenses, we have not left out the judiciary. They are part of it.
So tell us about the day, the event, the talk, and what to expect.
The event is coming on the 27th of November at the Labadi Beach Hotel, 9:30 a.m. in the morning. And it will be on the theme of decriminalizing poverty, decriminalizing petty offenses in Ghana, because majority of the, as we said, offenders are poor people. And so once they keep being sentenced, given custodial sentences, it is poverty that is sending them there. So we should decriminalize poverty more or less. So 27th November at Labadi Beach Hotel, the campaign launch will take place. And we are encouraging, we thank you for the platform. We encourage the media, civil society, and the general public to support us to ensure that petty offenses are decriminalized from our books, and so that the rights of ordinary citizens who are in the majority are respected.
Who will be speaking?
We will have a justice of the Court of Appeal. We will have SHRAJ, which are partnering Commonwealth Human Rights Initiative. So officials from SHRAJ will be speaking. We will have officials of lawyers. We have lawyers who come and have a panel discussion to dissect and explain all this.
Okay.
Now, also just to add that the judiciary have not also, turned a blind eye to this issue. You look at the case of Martin Pebu and the AG, where the Supreme Court has actually ruled that even giving bail to certain offenses is a human rights issue, and therefore, so the judiciary, there are reforms there, and they are also buying into the process.
Even after that, we still see some very curious cases that are denied bail. But I want to say thank you to you both for making the time to educate us. Mary Ajele Nate is the Greater Accra Regional Director of SHRAJ, and you've been hearing from one of the project officers at the Commonwealth Human Rights Initiative, Anthony Sejuro.